You're listening to Black Agenda Radio. I'm Margaret Kimberly. The landmark Voting Rights Act has been weakened over many years by court decisions. The recent Supreme Court ruling in the case Callais versus Louisiana has eliminated a majority Black congressional district in the state of Louisiana and has in fact said that such districts cannot exist. We're joined by Alanah Odoms, Executive Director of the ACLU of Louisiana, and she joins us from New Orleans to provide analysis on the impact of Callais versus Louisiana on that state and beyond. Thank you so much for joining me.
Thank you so much for having me.
Talk to us about the history of the Voting Rights Act and why it was needed at all.
We really can't have a conversation about the Voting Rights Act, which was passed in 1965 and is known as the crown jewel of the civil rights movement, unless we talk about the Reconstruction Amendment. So we really have to take a step back even further to really know why the Voting Rights Act was passed and necessary. So after slavery, of course, this country was broken down and separated by this idea of the South wanting to protect and preserve slavery. And the Emancipation Proclamation, which was signed by Lincoln in 1865, sought to abolish slavery. But many states, obviously, of course, did not want to do that. But more importantly, they did not want to allow formerly enslaved people to have what we call fundamental civil rights. And so what we saw is that formerly enslaved people really understood that the key to their citizenship and the key to their participation in this country would be around their political participation. And so there was much activism around having people who fought in the Civil War have the right to vote when they returned. And so there was a lot of organizing, a lot of strategizing around that. So the 14th Amendment and its kind of passage in Congress really looked like Black people really advocating for their fundamental civil and civic participation in this country. And then with the 15th Amendment, essentially this was outlawing racial discrimination in voting, but really only for Black men. And so you would think that the 13th, 14th, and 15th Amendments would have been enough to protect Black people and their right to vote. But what we saw after Reconstruction, where we saw lots of Black participation and lots of people elected to state offices, but also even to the United States Congress, there was a wave of white terror and violence that really moved across this country. There was 2,000 people who were empowered as a result of the Reconstruction Amendments to participate in our state political operations and in the federal government. And 2,000 people were lynched and beaten and killed in the backlash. And so what the Voting Rights Act did essentially was it almost provided a seatbelt for what the 15th Amendment was supposed to do. It wasn't enough to have an amendment that said you can't discriminate against Black people. We had to go even further. Congress had to go even further and solidify and cement those rights in the Voting Rights Act. And that wasn't given to us. That was as a result of our activism, our engagement, our litigating in courts around the country to be seen as free, to be seen as citizens, and to be given the right to vote.
And over the years, we've seen the Voting Rights Act being chipped away. First, the previous court did away with the pre-clearance provision, which said that certain states had to be cleared in order to make any changes in voting procedures. That was done away with. Now we see this Callais v. Louisiana decision, which said there cannot be, did they say there cannot be a majority Black district, or what exactly did they say about this particular district and other congressional districts across the country?
Yeah, in essence, they did say that you can't have majority minority districts so long as the state, the legislature, can make up a reason why they want to have Black participation lessened, as long as they can articulate a partisan reason for doing that, or as long as they can articulate really any other reason. Plaintiffs cannot meet the standard, the new updated standard under Section 2. I think the best way to understand this case is that the Section 2 protections were really a series of very important analyses to look at whether there is Black political and geographic populations in any city or state that would be voting in such a way where if they were allowed to be voting together and having the same kind of having the same opportunity to be grouped in the same district, they would elect a different candidate than if they were grouped with white voters. That is the idea behind racially polarized voting. It actually happens, and it can be explained best in two ways. Even folks who occupy the same party, if I'm a Democrat and then I have a white Democratic colleague, if you have racially polarized voting, you have a situation where even though the electorate may also be a Democratic electorate, white voters would not choose a Black candidate. We have had racially polarized voting in the state of Louisiana since the passage of the Voting Rights Act. And evidence of that is that we've never had a Black person elected to a statewide office in Louisiana since PBS Pinchback during the time of Reconstruction, and he only served for about 35 days before the legislature eliminated his seat. So that is to say, Section 2 is really this idea of, if we know that the penchant, the affinity of the legislature is likely to draw districts in such a way where either Black people will be packed into districts where they will have less power, or they will be cracked across districts to have less influence, Section 2 will prevent that. That is the harm of what we lost. They didn't go as far as to say you can never create majority minority districts, but what they did was they eliminated this real, I think, protection around packing and cracking. And they said, yes, you can actually pack and crack districts so long as you have a reason for doing it. And we will say that partisanship is a good enough reason to do that. We'll say that incumbency is a good enough reason to do that. And really what that does is just give hyper-Republican legislatures the green light to give pretextual reasons for racially motivated behavior.
So we know that districts are drawn, you can call it gerrymandering or whatever you like. Districts are drawn in order to favor one party's chance of winning versus another party, or to keep certain groups together, which has the result of ensuring a victory by one party or another. Did they not take into account that districts have been drawn in order to dilute Black voting power?
They actually claim that we're in a post-racial society. I think the majority opinion talked about the fact that it is very difficult to find intentional discrimination in voting, and that we should all be celebrating that. This is evidence of the fact that this court is grossly out of touch with what's happening in the American South. They're grossly out of touch with what's happening across this country. And I think you only need talk to any voter in the state of Louisiana to know that intentional discrimination still exists very much here. And if you didn't believe it before Callais came down, you can certainly take a look at what's happening across the country now to see that just like after the Shelby County case, we saw many states move to erase or dilute Black political power. It's the same thing is happening. You see Tennessee thinking about how they might have a special session to draw new maps to crack the Black district in Memphis, Tennessee. You see in Georgia calling for a special session to take away congressional representation there. This is happening across the country. And I think what happened in this kind of history of cases that weakened the Voting Rights Act, you spoke about Shelby County. There was another case called Rucho. And what the Rucho case said was that you can do partisan gerrymandering. And that was the opening. I think it was the crack in the door that really kind of allowed Callais to like really open this floodgate of nefarious discriminatory behavior that can be couched as partisan gerrymandering. We're not doing anything more than just trying to get more R's elected to office. We just want to protect our incumbent Republicans. However, we're going to do that at the expense of Black and brown voters across this country, and the Callais decision greenlit that rationale.
We've been talking about Black voters, but this decision does not affect only Black people, correct?
Oh my gosh, this is the best and most important salient point that you and all of our listeners can understand. We are talking about Black participation in the state of Louisiana, but we are actually talking about the Voting Rights Act covers all racial and ethnic minority groups and language groups. So, for example, we have a very large Vietnamese speaking population in the state of Louisiana. They would be covered under Section 2 of the Voting Rights Act. Our Hispanic and Latino brothers and sisters also covered under Section 2. Asian American, Pacific Islanders, Indigenous people, Native people, all of those groups are considered protected under Section 2 of the Voting Rights Act. And what happens when Black people's rights to vote are diluted, as you know, if you know anything about our history, everyone else also suffers the same way. So while we were the folks who fought for the passage of the 14th Amendment and for the passage of the 15th Amendment, our work in that process helped to enfranchise all ethnic and minority groups. And the reverse of that logic is also true. If Black people lose political participation, then all ethnic and racial minorities also lose it.
And I think people connect the Voting Rights Act provisions with the South, but that is not true. I live in New York, and we have, for example, with the pre-clearance provision, New York State. So, for example, in Chinatown in Manhattan, ballots had to be printed in Chinese, in Mandarin, and in English. And that could not be changed without permission from the Justice Department. Although I suspect that no one here, at least currently, will want to do away with those provisions, ballots having to be in Spanish or other languages, many different things, or lines being drawn, that had to be approved. And all of that is gone the requirements are gone for the entire country. And we're now relying on the goodwill of people in all 50 states to prevent discrimination. How well is that going to work?
I don't believe it's going to work very well at all. I mean, I'm from the state of New Jersey, and so I know that in states, for example, that have some Democratic representation, either in the governor's mansion or significant Democratic representation in state legislatures, those states likely have state voting rights protections that would ensure that some of the same provisions that existed in the federal law are actually present at the state level. So they are going to be faithful to that. The problem is for states like Louisiana that don't have voting rights protections at the state level. We actually introduced legislation this session to try and do that. And of course, it was summarily dismissed. We don't have a state constitution or any we have constitutional provisions for voting, but they don't necessarily give the added protections that, for example, pre-clearance would have given to us. We are going to, be, I think, in a very precarious position across the country, relying on the goodwill of legislators, because we see that everyone now is in a race to try to garner as much representation for their party as they can. And now party politics have been conflated with race. But in the American South, as we know, by and large, Black voters are Democratic voters. Although there are many white voters who are also Democratic, the Republican Party in the South is largely comprised of white people. And so merely saying that you want to get more Republicans is essentially saying in the American South that you want more white representation in elected positions.
And the impact has been immediate. You touched on briefly the fact that the state of Louisiana is going to go into special session to immediately redraw districts. What is the outlook for that?
Yeah, so we actually, the governor doesn't even need a special session. We are actually in regular legislative session right now. They are going to amend an already existing bill that was introduced to essentially append new maps, congressional maps, onto that instrument. That's going to happen as early as this Friday. We've seen potentially a variation of the map that is a 6-0 map, which would mean there would be 0 districts for African American people of the 6 districts that we have, which would completely eviscerate Black political participation at the congressional level in our state. We've also seen a variation of the map that would be a 5-1 map, which means we would lose 1 congressperson as opposed to 2. But I'll tell you, this goes even further. This governor and attorney general and secretary of state are in a conspiracy, not just to affect the congressional maps, but also to target Black elected leaders in the city of New Orleans, and also those folks who are elected officials in our judiciary. And furthermore, they've gone to an extraordinary maneuver to actually cancel our primary election. So your listeners may know that we have an election that is scheduled for May 16th. There are the primary for our congressional races on that ballot. There's a Senate race on that ballot. There's also Public Service Commission, State Supreme Court, constitutional amendments. That early voting for that election began on Saturday. The governor, I want to say on, I think it was Thursday or Friday, issued an executive order canceling the primary part of that election. So the election as it relates to the congressional race, canceling that part and saying that part would no longer go forward. So we've really never seen in our history an attempt to kind of bifurcate or take out a part of a already kind of an already in process election. And he is doing that based on this idea, unfounded, we believe, that the Supreme Court authorized him to cancel the election based upon the Callais ruling. So he's gone forward, used a very specific statute that talks about natural disasters, for example, something like Hurricane Katrina, where people aren't actually in the state to vote, to kind of use it as a maneuver to declare an emergency. Well, the Secretary of State declared the emergency for him and greenlit him to do this maneuver where he could essentially cancel the election as it relates to the primary. And so that's one tactic that they've used. Then they have also gone about this very, very nefarious process of eliminating Black judges in the city of New Orleans. And they've targeted about 6 different judicial seats, some on the civil district court, some on the criminal district court. But largely, as your voters and listeners may know, New Orleans is one of the most diverse, essentially the Blackest parish in the state of Louisiana. And so as a result, it has more representation by way of its state court judges and elected officials than any other place in the state. And so this governor has really kind of set his sights on erasing that political participation as much as possible. He put this into effect before Callais, but now that Callais has dropped, there's even more energy around these targeted attempts. One of the cases that you guys may be familiar with, where we're actually representing a gentleman by the name of Calvin Duncan. Calvin Duncan was incarcerated for 30 years at Angola. He was exonerated by the Innocence Project and had been wrongfully incarcerated for all of that time. He decided during that period of time, he began studying the law and actually served as one of our most effective jailhouse lawyers that ever was to practice at Angola, helping people get their records, especially from New Orleans, which is a place that is notoriously hard to and lacks transparency with regard to records for criminal defendants. He was very successful in his efforts, and once he was exonerated, he went to law school and graduated from law school, and then decided that he wanted to run for clerk of court of criminal district court in New Orleans. He won that election in a landslide by 68% of the vote. This governor and attorney general used the legislature in a very pretextual manner to eliminate the seat of this criminal district court clerk before he was sworn in. And we challenged that in federal district court and got a ruling from the federal court that said in 49 pages that they believed that the actions that the governor took were pretextual. And that word pretextual is really important, because what it means is I'm telling you one thing, but the real reason is another. And that real reason is this governor and others have their sights set on attacking Black political participation, disenfranchising voters, Black voters in particular in New Orleans, and they're going to tell you whatever reason they want to tell you for it. So this isn't Calais. I would say the best way I can describe it is Calais has greenlit Republican legislatures and Republican governors and Republican secretaries of state to play in our faces about voting, and really looking to use any kind of maneuvers that they can, whether it be loopholes in the Constitution, executive orders, emergency orders, things like that, to bypass the voters and to push forward policies that will limit or erase Black political participation.
Your work at the ACLU of Louisiana, what, if anything, can you do to fight this decision?
Yeah, so we're continuing to litigate on many fronts. So we have a case that is filed in the Middle District of Louisiana challenging the governor's executive order and articulating the disenfranchisement arguments I spoke to you about, and really kind of calling the question on can a governor cancel an election midway? That is the central heart of that lawsuit. We're hopeful that that is going to be successful. We're continuing to fight in the Calvin Duncan case. That case is now up before the United States Fifth Circuit. They've stayed the federal district court's opinion, holding SB 256 unconstitutional. So SB 256 was the bill that actually eliminated the clerk's position. We got the federal court to find that that was unconstitutional, and then the state came and appealed that to the Fifth Circuit. So right now everything is on pause, but we will continue to push in that case. And as I mentioned, what's happening on Friday is these new bills are going to be introduced. So we'll be doing legislative work to prevent the passage of any bill that would either be a 5-1 map or a 6-1 map that would eliminate our congressional representatives. So we'll be working in the legislature with our partners there. And then as it relates to the community, we are asking them in this election to go out and vote, to early vote, to make sure that they vote the entire ballot, not to be confused by this idea that certain parts won't count and this piece will be this and this piece will be that. Those are all mechanisms to confuse people. We're asking them to vote. We're asking them to vote early, and we're asking them to vote the entire ballot, and making sure we can help get as many people turned out to the polls for this election as we can.
And how do our viewers and listeners find out about the work of the ACLU of Louisiana?
Please follow us at laaclu.org. You can find all of our information there. You can also follow us on our social media channels. You can follow us on Instagram, and you can also follow the ACLU, because our national ACLU is partnering with us on many of these cases and is also going to have a lot of important information.
Well, thank you. Thank you so much for joining me.
I'm so happy. And to all of our listeners, although this is a moment where we are being attacked, I want to leave you with this idea that we have everything that we need from our lineage to our history of fighting for the Voting Rights Act, and the power that we have now is not diminished. It is only the time that we have to rededicate ourselves to those founding principles. And we have been the people to make this democracy fully live up to its ideals from the beginning, and it's our chance to do that once again.
Thank you. And that was Alanah Odoms of the ACLU of Louisiana, discussing the impact of the Supreme Court decision in Callais versus Louisiana.